In our previous study, we looked at terms of contract, whereby we answer the question, what is a term of contract? Then we went on to look at methods of incorporating contracts, of incorporating terms into contracts. And then we went on to look at different types of terms. For instance, in respect of the second item, we're looking at how terms are incorporated expressly, tacitly, or by implication. Then we went on to look at types of terms, and we looked at the essentialia, the naturalia, as well as what we called the incidentalia or incidental terms. And then we went on to look at, to give a rundown of some of the terms, whereby we said there's a condition, there are time clauses, there's a supposition, we have warranties, we have a modus, we have forfeiture clauses, we have penalty clauses, we have cancellation clauses, and we have entrenchment clauses. So today we are going to hit the road running by looking specifically at what is called a condition. Now, a condition is a type of a term whereby, well, as we depart, we must understand that the ordinary use of the word condition is not exactly, it doesn't mean exactly what we mean in law when we talk about a condition, particularly in respect of a contract. A condition is a term of contract which makes the operation of a contract contingent upon the occurrence or non-occurrence of a specified and certain future event. So, a condition, as we have said, it is a term which places a contract contingently upon the occurrence of a future event. It may affect the coming into effect of a contract, or it may affect the termination of a contract. For instance, we have different types of conditions. We have suspensive conditions, those that suspend the operation of a contract. And then we've got resolutive terms, which determine when a contract will come to an end. So, we are saying a condition has three elements. The first is a specified event. It is specified. In other words, there is no doubt in terms of which or what kind of an event must occur. So it is specified but uncertain. That's the second element. It is an uncertain future event. We are not exactly sure whether it will happen or it will not happen. Because if we know that it will happen, then it ceases to be a condition. It becomes something else. And then, so it's an uncertain future event. For instance, it may be a clause in a contract which says, X will buy a house if it rains tomorrow. I'll buy your house if it rains tomorrow. Or I say to you, I'll buy your house if my banker approves my loan application. So in that case, obligations do arise, but they are kept at bay. If the banker approves my loan application, then I'm bound to buy the house, to deliver the price to you. But if the banker doesn't approve of my loan application, and we get to a time when maybe the banker gives me notification that the loan application cannot be approved, then the contract falls away. So that such a clause would have served as a suspensive clause. It suspends the operation of the contract until a certain time. And then, so we are saying it's an uncertain future event. It's a future event in the sense that the event has not yet happened. For instance, when I say I will buy your house if my banker approves the loan application. The approval is going to take place in future. Can you take note of the difference here? Suppose I say to you, I'll buy this house on condition that the banker has approved my loan application. In other words, I have made a loan application to the banker, and the outcome has already been made, but I have not been informed about the outcome. Then I say to you, I'll buy the house on condition that the banker has approved my loan. In that case, it's not a condition, as we shall see when we discuss a supposition. That's what it is. It is a supposition. So a condition always deals with a future event, not an event that has taken place. So that's very, very important to take note of. I will buy the house if the banker approves of my loan application. So I have to make this a clear distinction or emphasis from the word God, because many students mix a condition with a supposition, and they get very, very confused. A supposition deals with an event that has already occurred, which only the parties may not be informed about at that time, but it has already occurred. Whilst a condition deals with a future event, an event that is yet to occur. So that's very important. Why do we even, belabor all these issues about distinguishing between a supposition and maybe a condition? The issue is that a condition is very essential to talk about when we are looking at the passing of risk. So once a contract is signed, then somebody between the two contracting parties bears the risk. For instance, if you sell me a horse or a cow, and I pay the purchase price, and then a day or so later, before it is delivered to me, let us suppose that it catches a disease and dies. The question then is, who bears the risk of the death of the cow? Is it the one who sold it or the one who bought it? So if the contract has fully matured, and maybe delivery was supposed to have taken place, and because of my fault I did not allow the seller to deliver the beast, then the risk lies with me. But if maybe I had expected the delivery, and then the seller had not delivered the beast by the time it dies, and the seller was in mora, that is in breach, then the seller would bear the risk of the death of the beast. So in the case then of conditions, we are looking at how the condition affects the passing of risk. A contract that is subject to a condition means that until the fulfillment of that condition, the obligations are kept at bay. They are kept in abeyance. The creditor cannot claim performance until the condition has happened. So we are saying it is very important then for us to understand that. So we are dealing here with two types of conditions, as I have already said. There's a suspensive condition and a resolutive condition. Now, a suspensive condition suspends the operation of the contractual obligation until the fulfillment of the condition. A valid contract does arise on the conclusion of the contract. Obligations arise, but their operation remains suspended until the occurrence of the specified but uncertain future event, as we have said. For instance, If Susan says she will buy the house until, or she will buy the house if she gets a promotion at her job, it as long as she has not got a promotion, that contract and its in fact the obligations of the contract cannot be enforceable. Now, a resolutive condition works differently in that it marks the end or the termination of a contract. The continuation of the contract or the existence of the contract terminates when a suspensive condition occurs. For instance, as we have said, in respect of a suspensive condition, you find that a resolutive condition means that a contract does come into effect immediately, but once the condition is fulfilled, it terminates. For instance, what if Jabulani says he lets his house to Tsepo on a contract, but the contract will the contract will dissolve and come to an end if Tsepo gets married. So the marriage of Tsepo in this particular instance terminates the operation of that contract. And we are saying at the dissolution, each party has to return what he or she has received in terms of the contract, depending on the circumstances of the contract. So that's how conditions work. Now, a condition must be distinguished from a time clause. Our next item, therefore, is to look at time clauses and how they operate. Unlike a condition, a time clause, a contract subject to a time clause becomes operating on reaching a certain determined or ascertainable time. For instance, you will deliver 50 tons of, say, 50 tons of grain to my factory until Christmas this year. So that makes the contract subject to a time clause, which means you will be expected to deliver 50 tons every day until the Christmas. On the 26th of December, I cannot expect you to continue to deliver. So we are saying such a contract is subject to a time clause. It's not subject to a condition, but it is subject to a time clause because it is a ascertainable time, or it is determined already. Maybe somebody says you will deliver groceries for the next 6 months, commencing from the first installment. So, or somebody says I expect you to work for me for a 5-year period. So we know at the end of the 5-year period, that contract of labor comes to an end, it's terminated. So we've got a lot of contracts that are subject to time clauses. For instance, the assurance policies, life policies, like somebody takes a policy, an insurance policy in favor of his or her children, and then that policy matures on her death or on his death. That's a time clause. So then, looking still at these conditions, they are also suspensive or resolutive, depending on how they are crafted and what impact they are meant to have. But as we said earlier, a suspensive time clause postpones the operation of the contract, whilst a resolutive time clause extinguishes the operation of the contract. Now, having spoken about the time clause, our next item is a supposition. You would remember that when we were talking about a condition we did allude briefly, just in passing, we mentioned a supposition. Now let's look at how a supposition works. Parties want to contract if a certain state of affairs may exist, and then a supposition is a term which places the contract subject to a state of affairs which already exists, or an event that has already occurred or taken place, but which the two of them may not know about. For instance, the parties may conclude a contract which only becomes operative if the state of affairs exists. I gave an earlier example, and I repeat now and say, X buys a farm on condition that there are coal deposits in that farm. So Mr. Y is selling a farm, and X says, yeah, I want that farm, and I'm going to pay you X amount of rands or dollar, whatever, pounds, whatever currency is in use. But I will only do so on condition that there are coal deposits. So somebody must then go out and prospect for coal deposits. If eventually those coal deposits are found, then X will have to pay, and the contract becomes operative. But if after a diligent search by geologists, they do not find any coal deposits, then X is not obliged to pay the price. That's how a supposition works. In other words, Mr. X is saying, I will buy your property supposing that there are coal deposits there. So since the seller doesn't undertake to guarantee the existence or the presence of coal deposits, he only commits to the sale subject to verification that there are such coal deposits. So that's how a supposition works. So far we have looked at a condition, we have looked at time clauses, we have looked at a supposition. Now I'd like us to look at a warranty. In the case of a warranty, you find that a party accepts absolute responsibility for proper performance relating to the absence of defects in the product or the service being rendered. I am selling you a computer for the next 3 years. It is going to function perfectly. The Windows program, whatever program, operating system will function perfectly. If it crashes before the end of the 3-year period, I promise you a full repayment. That's how a warranty works. So we are saying it is accepting responsibility for the proper performance relating to the absence of defects. It speaks to the quality of the item. It's a qualification of the nature of the obligation, and it is an additional obligation to the contract. I sell the fridge to you subject to a warranty that for the next 2 years the color of the fridge will not change. So once the color begins to fade before the end of the 3-year period, then you come claim your full refund or get another fridge. So whether a warranty exists or not in a particular contract, it's a matter of interpretation based on the specific terms. Now, some warranties are imputed by operation of the law, and others are expressly incorporated by the parties concluding the contract. For instance, we have said that a contract of sale carries with it a warranty against latent defects. So, but in certain cases, you find parties expressly incorporate these warranties. So, depending on whether it is expressly incorporated or whether it is imputed by the law, it operates in favor, usually, of, if it's a sale, it operates in favor of the buyer. So, there are also such warranties as warranty against eviction imputed by common law in all cases where you purchase Now, another important term is what we call a modus, whereby a burden is imposed upon a contracting party, to the one who has a right to performance finds that there is a burden that runs against their favor in terms of the contract. The burden usually relates to a future occurrence, and it may even include a duty to perform. Take an example of a father who donates a car, a motor vehicle, to his eldest son on condition, rather subject to, let me avoid the word condition because it mixes things up sometimes, subject to a requirement that this particular son will use that motor vehicle to carry his legal sister to school every school day. In this case, we are dealing with a modus, which is a burden upon the gift, a burden upon the donation. The son receives ownership of the vehicle, but it's subject to the condition. And it's subject to the modus, the burden. And what is the burden? He must carry or transport his little sibling to and from school every school day. That's how a modus works, as a burden. And then, well, other terms is we have already indicated. We have a cancellation clause, a penalty clause, a forfeiture clause, or an entrenchment clause. Now, how do these work? We're not going to spend much time on this, but just give a brief summary. In the case of a cancellation clause, you find that parties agree that each party will be free to cancel the contract once the other party is in breach. So in other words, we agree that if you breach the contract, I will cancel. So once you act in breach, then I am entitled to cancellation of the contract. And then sometimes such a cancellation clause may then go with a penalty clause, or they may operate independently of each other. In the case of a penalty clause, the parties who find that the common law remedies for breach of contract are not sufficient for their own purposes may decide then to incorporate some customized remedies. They may craft their own remedies designed in such a way as to take care and address their own needs in terms of the contract. So then they incorporate a penalty clause in terms whereof the party in breach of contract is going to suffer penalty, is going to maybe pay a certain amount to the aggrieved party. There may also be forfeiture clauses whereby you find a certain party, especially the party who is in breach of contract, forfeits certain benefits accruing in terms of that kind of a contract. You will agree with me that in terms of the common law, if parties are in a contractual relationship and maybe there's a breach or something like that, one of the parties is aggrieved, the other party may also usually be entitled to restitution of the performance that he or she would have rendered up to the time of the breach. But in terms of a forfeiture clause, you find that the party who is found to have been in breach forfeits the right to claim restitution once that contract is terminated. So that's how a forfeiture clause works. And then you may find in certain instances parties, or rather a contract, incorporates an entrenchment clause whereby certain rights or certain processes are entrenched. A simple example would be a clause or a term where the parties agree that they are not going to alter the terms of that contract, or they agree that if they need to alter the terms of the contract for any reason, a verbal alteration will not be sufficient. In fact, then they agree that they will have to commit what you call this, the alteration of the contract, or the amendment of the contract will have to be done only in written form, not on an oral basis. Thank you very much then for being part of this lecture series on the terms of a contract. Now I guess you know what a term of contract is. You know the three methods of incorporating terms in a contract, namely expressly, tacitly, or by implication. And then you also now fully understand the essential elements, what we call essentialia terms, the naturalia as well as the incidentalia. Those are terms of a contract. And then you also know how a condition works, how a time clause works, how a supposition works, how a warranty works. You also know what is a forfeiture clause, a penalty clause, a cancellation clause, or an entrenchment clause. Thank you very much for being part of this class. Looking forward to meeting you next time on other issues. Don't forget to subscribe and follow our channel so that we get feedback and we get to update you whenever there are new videos coming up. Thank you very much. Enjoy the rest of your day.